Hello, everyone, and welcome. And thank you all so much for joining us for today's webinar, Colorado Paid Leave Regulations, Understanding Upcoming PSST and PFML Regulations. We ask that you please post any questions you have in the Q&A today, as opposed to the chat. We will try to get to as many questions as we can in the time allotted after the main discussion. In the chat box, you will see that the link to the slide deck for today's call will be shared. Today's presentation is being recorded, and the recording and the slide deck from today's webinar will be shared with you within 24 hours. At this time, I would like to introduce our speakers for today's webinar. Joining us today are Lori Fischler, Council Benefits Compliance, and Tina Neuendorf, VP of Strategic Development. Tina will now open the call. So Tina, the floor is yours.
Good morning, and thanks, Libby. We appreciate everyone being available to attend this morning's webinar. Since this summer, Colorado has passed several paid leave provisions, which employers need to be aware of. The first one is the Healthy Families Workplace Act, which was passed back in July, and the more recent one is the Proposition 118, also known as the FAMLI Act. With this, Lori, we're pleased to have available today to speak to both of these regulations and what it will mean for employers to adhere to in the upcoming plan years. With that, Lori, we're pleased to have you on board.
Thank you very much, Tina and Elizabeth, and welcome everyone, and thank you for joining us this morning. I look forward to discussing these new regulations with you and hope to be able to present you all with a better understanding of how they differ from one another and how they may interplay and overlap in the future. And with that, let's go ahead and get started. For starters, I do want to just remind everyone that while these laws did both pass this year, one of them in particular, the Family and Medical Leave Insurance Act, has not yet released total guidance on how that will be implemented and administered in the future. So all information presented today is current as of this month, December 2020. Tina did mention to you the agenda, but let me just go over it again with you right now. We will begin our presentation by reviewing the Healthy Families Workplace Act. Again, that was passed earlier this summer, and I will present the three different components of that law that is currently in effect and the pieces that will roll out in the future. Next, we will move on to the Paid Family and Medical Leave Insurance Act, otherwise known as FAMLI. Again, that was known as or referred to as Proposition 118 on Colorado's November ballot. That does not actually roll out until 2023 and does not actually provide leave benefits to employees until 2024. However, we will share with you what we now know about those provisions and regulations. Okay, with that, let's go ahead and get started. Healthy Families Workplace Act, otherwise known as HFWA. And I'm going to pause right here. You're going to hear a lot of acronyms, unfortunately, from us today. Please feel free, if you need further clarification on those acronyms, please feel free to chime in the chat box, and I'll try to clarify those for you after the presentation. But again, HFWA, Healthy Families Workplace Act. Think of this as Colorado's version of paid sick leave. As of right now, Colorado is the 17th state in the nation to go ahead and pass a paid sick leave law. And your law is known as the Healthy Families Workplace Act. This became effective this past summer, specifically on July 15th, and it terminated Colorado's previous law known as HELP. HELP, unfortunately, only applied to certain industries: leisure and hospitality, retail, food services, childcare, education, home health care, nursing homes, and community living facilities. And HELP was specifically enacted in March as part of the COVID-19 relief that the state passed prior to the federal FFCRA and the Federal CARES Act. It only provided paid leave for flu-like symptoms and for testing for COVID-19 isolation and or quarantine. So again, the Healthy Families Workplace Act went into effect July 15th and essentially eliminated and replaced Colorado's HELP provisions. Now, I'm a graphic person, and Tina and I have spent a lot of time getting our arms around these two different laws, and we found that it really helped us if we visualized it in a graphic form. So we thought it might be helpful for you as well. So we're sharing that graph here with you on this slide. And it's really helpful to think about the Healthy Families Workplace Act, otherwise known as Colorado's paid sick leave, as two different buckets of leave benefits. Over there on the left, you'll notice the COVID-19 relief bucket. And that is really those benefits that the state intended to roll out to all employers. Under the federal FFCRA, Families First Relief Act, and the Federal CARES Act, which were released early in the spring of this year, employers with less than 500 employees were obligated to provide certain types of leaves and benefits to their employees as a result of the COVID-19 pandemic. Colorado enacted this piece of the Healthy Families Workplace Act as a way to roll out those benefits to larger employers, employers with 500 or more employees. So that's what that provision of the Healthy Families Workplace Act is intended to cover. It's almost identical to the federal relief packages under the FFCRA and the CARES Act. The only difference is that it rolls it out to all employers of all sizes. Now, one key piece of information to remember about this bucket of relief is that it does expire at the end of this year. So employers are only obligated to continue providing that COVID-19 relief until December 31, 2020. Now, unless, of course, the federal government steps in and or Colorado's own legislature steps in and extends that relief, we will anticipate that expiring at the end of this year. So because of that, we're not going to spend a whole lot of time in today's presentation going over those relief benefits. I'm happy to discuss those with any of you one-on-one at any time if you need further clarification. We will also be distributing and publishing these slides after our call today, and the published version of today's slides will include additional slides that provide a refresher of that COVID-19 relief. So today's presentation will primarily focus on the bucket on the right, the PSST relief. That stands for Paid Sick and Safe Time. That is Colorado's version of paid sick leave that will kick in January 1, 2021 and extend for years into the future. There are 4 different types of leave within PSST, and that's what I'd like to spend some time discussing with you today. Again, a brief overview. The COVID-19 relief provided under the Healthy Families Workplace Act kicked in on July 15, 2020. It replaced HELP, and it is due to expire at the end of this year, unless, of course, we see further action either by the state legislature or the federal government. However, it is the Paid Sick and Safe Time, PSST, that we're going to focus our attention on today. It rolls out in 2 phases. Beginning January 1, 2021, it will apply to employers with 16 or more employees. And on January 1, 2022, it will apply to all employers of all sizes. Now, many of you may be asking, how do we determine our size? How do we count employees to determine whether or not we are obligated to comply as of January 1 of this year, or whether we have another year to get into compliance? Well, that 16 employee account begins, you take that count on January 1, 2021. And once we move forward, we'll look and determine what kind of employees you actually count. So employers must provide paid sick and safe time to all employees, essentially all employees, including full-time, part-time, temporary, and seasonal employees. The only employees you don't count in that calculation are independent contractors or employees who are otherwise subject to the Federal Railroad Unemployment Insurance Act. Okay? Generally, there are 4 types or purposes an employee may take paid sick leave or paid sick and safe time. And I like to think of those in terms of employee-based leave, family member-based leave, or leave related to a domestic abuse or sexual assault situation, or leave due to a public health emergency. And again, going back to our graph, those are the 4 buckets that we see under the paid sick and safe time: the employee-based leave, family-based leave, domestic or sexual abuse leave, and leave related to a public health emergency. So moving along, let's talk about the leave purposes as they're related to an employee's need. Well, here an employee may use the accrued paid sick and safe time to be absent from work when the employee has a mental or physical illness, injury, injury or health condition, or the employee needs to take time to obtain a medical diagnosis, care or treatment related to such illness, injury or condition, or when the employee simply needs to obtain preventative medical care. Again, I want you all to think of this as Colorado's version of paid sick time. So this is time that an employee would need to take for a doctor's appointment, or that you are simply ill and you need to stay home to either care for yourself or a loved one or family member. And very similar to the leave that an employee would need to take for themselves is the bucket related to a family member leave. And here an employee may use the paid sick and safe time to be absent from work to care for a family member for the same reasons: when the family member has a mental or physical illness, injury or health condition, or when the family member needs to obtain a medical diagnosis, care or treatment of a mental or physical illness, injury or health condition, or when the family member needs to obtain preventative medical care. So here, the employee would be taking the leave to assist the family member for any one of these reasons. Now, that third bucket is related to abuse or sexual assault. And this is where Colorado differs from many of the other states in the nation. Other regions across the country that have been passing paid sick time, their leave is simply related to days off for those type of medical appointments and family care. However, Colorado has gone a step above and gone a little further in that they are allowing employees to take time needed to care for situations of abuse or sexual assault. Here is when an employee can take time for themselves or for a family member who has been the victim of domestic abuse, sexual assault, or harassment, and needs to take leave to either seek medical attention related to that incident or needs to obtain services from a victim services organization, obtain mental health or other types of counseling, or to seek relocation or legal services, including preparation for or participation in a civil or criminal proceeding related to that incident. And last is the bucket related to a declared public health emergency. And here an employee may simply take accrued time due to a public health emergency that a public official has ordered closure of the employee's place of business, or when the public health official has ordered closure of the school or place of care of the employee's child, and therefore the employee needs to be absent from work to stay home to care for the employee's child. As you can see, this is clearly taken from the federal relief that's been provided in the FFCRA and the CARES Act as a result of the COVID-19 pandemic. Here, the Colorado legislature has simply taken steps to extend that type of relief to Colorado's future situations that may also involve similar types of public health emergencies. Again, I want to stress to you that the relief we are talking about under the Healthy Families Workplace Acts is again intended to be limited in duration up to 48 hours of leave. And let's talk about that. Let's talk about that 48 hours. Well, the accrual rate under the paid sick and safe time provisions of the Healthy Families Workplace Act provides that employees will earn 1 hour of paid sick leave for every 30 hours worked. So for full-time exempt employees, employers may assume a 40-hour work week. And when calculating that accrual rate for part-time employees, employers should assume that they shouldn't assume anything actually, I back up, pardon me. For part-time exempt employees, employers should calculate that accrual rate based on the hours each employee normally works. So unlike with a full-time exempt employee where an employer can assume a 40-hour work week, with part-time exempt employees, you don't make that assumption. Actually, you base that accrual rate on the hours each employee actually normally works. Now, employers can opt to accrue paid sick and safe time by hours worked or by providing a simple lump sum at the beginning of the year. What about cap and carryover requirements? Employers can cap the accruals at 48 hours per year. They can be more generous, but they cannot provide anything less than 48 hours. You must also allow your employees to carry over up to 48 hours of sick leave into the following year. But you are not required to allow employees to accrue anything more than 48 hours. So again, there are both carryover and cap requirements. You cannot provide anything less than 48 hours per year, but you do have to permit a 48-hour carryover, but you're not required to allow employees to accrue anything over that in any given year. What about notice requirements? Employers must allow employees to use paid sick leave upon the request of an employee. The request can be made orally, in writing, electronically, or by any other means acceptable to the employer. An employer may provide a written policy that contains reasonable notice procedures. However, they cannot deny leave based on noncompliance with those policy procedures. So again, very generous to employees. They can use their accrued leave as it is accrued, and they must be able to use that leave upon request. Even though an employer can request certain reasonable notice procedures, it's important to remember that you cannot deny the leave based on noncompliance with those procedures. When possible, the employee must include the expected duration of the absence. However, when the need for the leave is foreseeable, the employee must make a good faith effort to provide such notice in advance and make a reasonable effort to schedule the use of paid sick leave in a manner that does not unduly disrupt operations of the employer. An employer cannot require an employee to search for or find a replacement worker to cover the time the employee will be on leave. Again, paid sick time begins to accrue when employment begins, and employees may use accrued paid sick leave as it is accrued. Very important, accrual begins on the date employment begins, and employees can use that paid sick leave time as it is accrued. An employee must use paid sick leave in hourly increments unless the employee's employer allows paid sick leave to be taken in smaller increments of time. Otherwise, the default is hourly increments. What about when an employee terminates? Well, employers are not required to pay out unused sick leave time at termination. If an employee leaves employment, however, and is rehired within 6 months, the employees must reinstate all of the previously available sick leave time, unless, of course, it was paid out at separation. So the payout provisions are really an employer's discretion. You are not required to pay it out. However, obviously, if you do, then you do not reinstate it if and when an employee is rehired. What about any existing leave benefits? Well, if employers already provide paid leave that either meets or exceeds the requirements under the Healthy Families Workplace Act, then no further action is needed on your part. Employers can provide paid sick leave that accrues at a faster or more generous rate, and the law does not require a separate sick leave bank. So if you already offer an existing leave policy, please consult with either your counsel or your advisor or your NFP professional to see if those existing policies may already meet or exceed the requirements under the Healthy Families Workplace Act. If so, then it would be nice and you may not need to do any further action at this point. Now, I do want to pause and take just a moment to talk about leave in the situation of a declared public health emergency. And because this is quite interesting. Here, the Colorado legislature decided that in a public health emergency, such as what we're currently seeing right now under the COVID-19 pandemic, all employees will be entitled to 80 hours of sick leave. And 80 hours is provided for any employee who normally works at least 40 hours in a work week. So what employers are to do in a situation of a public health emergency is to simply supplement any already accrued time that an employee has earned so that that leave becomes available, so that the leave available is equal to 80 hours of sick leave. Again, 80 hours is what must be made available to an employee who normally works 40 hours in a work week. The greater of either the amount of time the employee is scheduled to work in a 14-day period or the amount of time the employee actually works on average in a 14-day period for employees who normally work fewer than 40 hours in a work week. So for part-time employees, you take the greater of the amount the employee is scheduled to work in a 14-day period or the amount the employee actually works in a 14-day period. So that's the calculation for part-time employees or employees who work less than 40 hours a work week. For anyone who works 40 hours or more in a work week, the employee must be given 80 hours, at least 80 hours of sick leave during a public health emergency. Again, you can see where this aligns with the federal benefits that have been offered under the Family First Relief Act and the CARES Act. Again, the Colorado legislature has just simply taken steps to extend those public health emergency leave benefits to future uses. Also, during a public health emergency, an employee may use the supplemental sick leave until 4 weeks after the suspension of the declared public health emergency. Generally, employees may use this leave to isolate, seek medical attention, or care for a family member due to a diagnosis, symptoms, or exposure to the cause of the public health emergency. Again, it is simply aligning with the type of relief we are seeing now under the COVID-19 pandemic. Documentation of paid sick and safe time. Well, employers do have some obligations here too. For paid sick leave for 4 or more consecutive workdays, an employer can require reasonable documentation that the paid sick leave is for an authorized purpose. However, during a public health emergency, an employer cannot ask for this type of documentation. Posting and recording requirements. Employers must supply each employee with a written notice. This can be done by adding a policy to your handbook or giving each employee a standalone written policy. Employers must also display a poster in a conspicuous location, and this poster can be obtained on the government's website at colorado.gov. Employers must also retain records of hours worked, paid sick leave accrued, and paid sick leave that's been used for employees for up to 2 years. And with that, we're going to go ahead and move on to the Paid Family and Medical Leave Insurance Act. I would like to pause, though, and just spend a few moments and talk about how these two laws differ. I did explain that the Healthy Families Workplace Act is really Colorado's version of paid sick leave. Well, if that is the case, then think of the Paid Family and Medical Leave Insurance Act, otherwise known as FAMLI. Think of that as Colorado's state version of the federal FMLA. Many states, I think we're up to now 9 or 10, already offer some sort of a state version of federal medical, family, and medical leave. This is simply Colorado's version of the FMLA leave. There are some differences, though, and most significantly, it's paid. Federal Family Medical Leave Act, FMLA, is not paid. It is simply a law that protects job status and benefit status of an employee. Well, FAMLI is a paid insurance act by which the state of Colorado will administer paid benefits to employees who become eligible. Also, a second distinguishing factor between this law and the Healthy Families Workplace Act is while Healthy Families Workplace Act was really intended for short durational leaves, no more than 48 hours each year, FAMLI provides much longer durations of leave, really intended to help employees with longer needs of leave to help serious health conditions, serious illnesses, and situations in which they may need to care for family members and for longer periods of time. So let's move on and let's dig into the weeds a little bit more around FAMLI. Well, FAMLI, you probably have heard about it, is referred to as Proposition 118, which did indeed pass the Colorado November ballot this last November. Again, it does not equal a Healthy Families Workplace Act. FAMLI, like the federal FMLA, provides up to 12 weeks of paid leave for employees. Employees may be eligible for an additional 4 weeks, up to 16 weeks, in situations of complications due to pregnancy or childbirth. This law, FAMLI, does not become effective until January 1, 2023, so we do have a couple more years to get into compliance. And actually, employees won't actually begin to become eligible for taking that leave until January 1 of 2024. Eligibility. Well, eligible employees are those who receive benefits after they have earned $2,500 in wages that were subject to the family premiums, and employees must have been employed for at least 180 days. I do want to point out here, too, that there is potentially some relief for smaller employers. The state has indicated that employers, so while this law does apply to all employers of any size who are based in the state of Colorado and employ at least one employee in the state has indicated that there will be relief provided to smaller employers, probably employers with 10 or less employees. And that relief, it seems to indicate those smaller employees will not bear the cost to contribute to the premiums. We'll get into this a little further down into the slides. I just wanted to point out here that while all employers are subject to FAMLI, it does appear that the legislature will offer relief to smaller employers, probably employers with 10 or less employees. Okay, what about reasons for leave under FAMLI? Well, unlike Healthy Families Workplace Acts, again, which was intended to cover smaller, shorter durations of leave, FAMLI will provide employees to take longer, up to 12 or maybe 16 weeks of leave for the following reasons: to care for their own serious health condition, to care for a new child during the first year after the birth or adoption, or for foster care of a new child, or to care for a family member with a serious health condition, or when a family member is on active duty military service or is called for active duty military service, and when the individual or the individual's family member is a victim of domestic violence, stalking, or sexual assault. The definition of a family member under this law, I do want to point out, is quite broad, and it includes a person related by blood, marriage, civil union, or adoption, a child to whom the worker stands in loco parentis or simply acting as a parent and raising a child, or a person for whom the employee is responsible for providing or arranging health or safety-related care. Again, a broad interpretation, a broad definition of a family member. I think that's important for all employers of all sizes to remember that definition. Also, I want to point out that the definition of domestic violence is taken straight from existing Colorado statutes that are contained in Colorado Revised Statute 18-6-800. So this is not a new definition of domestic violence. The domestic violence definition here that includes stalking or sexual assault, again, is taken from existing definitions of domestic violence that are already on the books in Colorado. Benefits. So what is an employee entitled to if they become eligible for leave under FAMLI? Well, again, it is an insurance premium that will be paid by both employer and employee contributions. We'll get into that on the next slide. But the benefits that an employee may be entitled to equal 90% of an employee's average weekly wage, up to that portion of wages that are less than or equal to 50% of the state's average weekly wage. Anything thereafter is paid at 50%. So what does that mean? Well, unfortunately, the legislature did not pass a simple sliding scale here. What they laid out in that ballot initiative is a more complicated calculation. We hope to receive more information on what these benefits actually look like and how they will be calculated when the government releases its guidance on this by January 1, 2022. But for right now, all we have is the language that was provided in the ballot initiative, and that defines the benefits as this: 90% of an employee's average weekly wage for the portion of wages that are less than or equal to 50% of the state's average weekly wage, and 50% of the portions of the wages that exceed 50% of that state weekly wage. So essentially, the state of Colorado determines what the state's average weekly wage is every week. What happens is an employee's benefit will be taken at 90% up to 50% of that state weekly wage. After that, their benefits are paid out at 50%. So I'm sorry, I know that's not a clear calculation. I know that may be confusing. We are hoping for further clarification once further guidelines are released. We hope in the next year or so. But until then, that's all I can really provide at this point. We are also working on a chart that we hope to be able to roll out to you that might help with this calculation. I don't really want to provide too much more, though, because anything at this point will be speculation. Again, until we receive further guidance from the state on how to perform those calculations, this is all I really have. Of course, we will continue to keep you apprised and educated as we receive more information from the state as well. We do know that beginning in 2024, all benefits will be capped at $1,100 a week. That was made very clear in the language. And we do anticipate that in 2025, the maximum weekly benefits would probably be capped at somewhere around $1,200 a week. So that I can provide with you right now. We also know that premiums will equal 0.9% of the employee's wages with a 50-50 split among employers and employees. Employers can, of course, choose to pay a larger percentage up to the full 100% if they choose. And as I mentioned earlier, we anticipate that businesses with less than 10 employees will be exempt from paying their portion of the premium. And also, in addition, sole proprietors can also opt out of the program altogether. Now, I know there's been a lot of talk around this 10 employee count and whether or not employers with 10 or less employees will be exempt. Again, the legislature has indicated that there will be indeed relief provided for smaller employers. It's interesting to note that we don't actually see the language 10 in the ballot initiative language. We only know that there will be some sort of relief provided for smaller employers, and there has been talk of a 10 employee threshold. So we will provide further information on that as we get guidance from the state. Beginning in 2025 and thereafter, premiums will be adjusted so that the total amount of the premium contributions to the program will equal 135% of the previous year's claims and 100% of the administrative costs. Premiums will ultimately be set up to a cap of 1.2% of each employee's wages. So in addition to the insurance salary benefits or salary supplement or pay benefits under FAMLI, FAMLI also provides general job protection benefits. Again, very similar to the federal version of FMLA. So employees who take paid family benefits, they're entitled to return to the same position or a position with the same pay, benefits, and seniority or status upon return. Again, FAMLI bars retaliation against employees who take leave, and employees who are on paid family leave. The employer must maintain any health care benefits the employee had prior to taking leave for the duration of that leave. Again, just like federal FMLA leave, job protection status, and benefit status. Employees who continue to pay their share of the cost of health benefits during the leave, well, employers are going to need, just like you would under federal FMLA leave, you will need to make sure you work those arrangements out with your employees prior to taking leave. So, for example, if an employee decides to continue those benefits during the leave, you're going to need to work out how premium contributions will be paid, whether they'll be paid up front, whether the employee will continue to send in checks each month, or whether the employer will front those contributions for the employee while on leave and then recoup them upon return. That's up to you. Just ensure to make sure that you are working those arrangements out with your employees prior to taking leave. I do want to point out, though, that employees who are on paid family leave do not accrue any other seniority or employment benefits during their leave. And again, that's very similar to FMLA leave, and it does also resonate here with Colorado's paid family leave. Okay, the interplay between Healthy Families Workplace Act and this new Colorado paid family leave, and potentially any other leaves that an employee may be eligible for. I want to talk a little bit about these, but I do want to stress that unfortunately, until we receive further guidance from the state on how the paid family leave will be administered, we just don't really know a whole lot yet. I'm happy to share with you right now what we do know, but I do want to stress that we do anticipate much more information on how the paid family leave will interplay with other leave programs once the legislature releases its final guidance, which it said it will do so by January 1, 2022. Also, it's important to note that the legislature has also stated that it will release, in addition to further guidance, it will release further training sessions as well on how this family leave will be expected to be administered. But what do we know right now? Well, we do know that paid family leave and FMLA, under both, employers may require that both the state family leave and the federal FMLA leave, that they can run concurrently with each other so that employees will not be able to stack those two leaves together and potentially earning them up to 24 weeks of leave. So again, an employer can require that an employee who may be eligible for both the state family leave as well as the federal FMLA leave, that those two leaves run concurrently so that an employee will only be eligible for up to 12 weeks of leave or potentially 16 weeks of leave. What about disability insurance programs? Well, we do know that paid family leave may be taken concurrently or otherwise coordinated with payments made or leave allowed under the terms of a disability policy. However, other than that, that's all we've been provided. So we do anticipate that the state will clarify and provide further guidance onto exactly how this coordination will work with paid family and other private disability programs. Until then, we'll just need to stay stay abreast of all of the further guidance that we anticipate will be released. What about paid family with existing vacation leave, sick leave, and other paid time off programs? Well, we do know that employers cannot require employees to use accrued vacation leave, sick leave, or other paid time off, including, by the way, paid sick time under Healthy Families Workplace Act, before or while receiving paid family. So you cannot require your employees to take other leaves prior to receiving paid family. However, an employer and an employee can agree that covered individuals under paid family can use accrued paid time off, think Healthy Families Workplace Act, to utilize family to top off their pay. So you can reach an agreement with your employee to use both the Healthy Families Workplace Act leave as well as paid family leave to top off their pay so that they can actually earn 100% of their paid time off during those qualified leaves. However, note, an employee is never entitled to more than what they would earn under an average weekly wage. What about other pre-existing agreements and policies, such as collective bargaining agreements? Well, right now, nothing under the law diminishes an employee's rights under those collective agreements, employer policies, or employment contracts. We don't expect that to change in the future. Of course, if we see any language that would diminish those rights, we will share them with you right away. And likewise, with workers' compensation and Colorado's existing domestic violence leave law, what we do know is that the state, quote, shall determine by rule the interaction of benefits or coordination of leave between the paid family requirement and the existing domestic violence leave law and other workers' compensation rights. So again, nothing has been decided on how those 2 or 3 laws will interact with one another. Stay tuned, and we will provide you with further guidance as we see it. So where does this leave us? Well, this leaves us with the Healthy Families Workplace Act and paid family. Again, I think it's very helpful if you think about it in terms of paid sick leave. Healthy Families Workplace Act equals Colorado's version of state paid sick leave. It provides up to 48 hours of paid leave, and of course an employer can be more generous, but you cannot provide anything less than 48 hours of paid leave. All employees accrue leave. That accrual begins on the date of employment begins, and employees earn accrued leave at the rate of 1 hour for every 30 hours worked. The cap is a minimum, again, of 48 hours, and employers must allow employees to carry over up to 48 hours, and the leave can be taken to care for yourself, a family member, leave to cover victim situations, or leave for public health emergencies, school and business closures. And there are documentation and posting requirements that are placed upon an employer. Please do, should have included this as the last bullet point, but please do remember that there are also recording requirements of an employer. So you do need to record your accrual rates and the times and days taken off by employees. Please reach out to your payroll providers, if possible, to see if they can assist with those accrual documentations. If not, you will need to work out some sort of a process, procedures by which you are recording these accruals and these leaves that employees are eligible to take. And as for Colorado's Paid Family and Medical Leave Insurance Act, just remember that it is very similar to the federal government's FMLA leave, only that it distinguishes in that it does provide paid benefits during those 12 weeks or potentially 16 weeks of eligible leave. Employees become eligible after they've earned $2,500 in wages that are subject to those premiums and have been employed for 180 days. Let's see, employees can take leave to care for their self or a family member. They can also take leave to cover victim situations. Premiums are funded using a 50-50 payroll tax split between employer and employee, and they are eventually capped at 1.2% of each employee's wages. And then remember that that benefit received is a calculation that's based on 90% of an employee's average weekly wage up to 50% of the state's declared average weekly wage for a week. And everything beyond that is paid out at 50%. It's not a simple sliding scale. It's a little bit more complicated of a calculation. We hope to receive more information or perhaps even tools that will help employers calculate that benefit in the near future. Until then, just stay tuned and just know that NFP will keep you apprised of further guidance that we receive on that. And all we can really ask you to do right now is please be sure that you review your existing policies for compliance. Remember that under Healthy Families Workplace Act, if you already have an existing policy in place, that either meets or exceeds the requirements under the Healthy Families Workplace Act, you do not need to do anything else. You can actually be exempt from the laws and just apply your own existing policies. So please review your policies, and we are here to help with those reviews. And of course, we're always available for further questions. And with that, Tina, I'm going to go ahead and open it up to questions. I see we have something in the chat box.
Yes, thanks, Lori. So I'm going to review those questions that we've received. The first one, Lori, within the slides, it mentions that this is applicable to all private employers. The question is, does this also apply to public entities as well?
And are we referring to Healthy Families Workplace or family?
The question didn't state that, so if you could preface.
Yeah, well, actually, the answer is the same for both. It does apply to all employers.
Okay, thank you. So it's applicable to any type of employers, private as well as public entities.
Yes.
Thank you. Second question, Lori, is if an employee leaves, is the employer required to pay out the accrued sick leave?
Yes, I think we did cover this, but let me cover it again. And I'm assuming you were talking about the Healthy Families Workplace Act because the question contains the word accrued. And so accruals only occur under the Healthy Families Workplace Act, otherwise known as paid sick leave. And no, an employer is not required to pay out any accrued paid sick leave time. That is an excellent question because other states have required employers to do so. Colorado did not require employers to pay out any accrued time. You can, an employer can choose to be generous and pay it out, but you don't have to. It is not required. One other little important related note along that line, though, is that upon termination, if an employee is rehired within 6 months, you must reinstate any accrued time that was previously earned. Unless, of course, you paid it out, then it's gone. You wouldn't have to reinstate it. But if you did not pay it out and that employee returns within 6 months, then you must reinstate that previously accrued time. I hope that addresses the question.
I believe so. Thanks, Lori. The next question we have is related to the Colorado PSST. And this employer has shared they've paid out 2 weeks of Colorado EPSL to many employees. Is the PSST during public health emergency in addition to that, or is it a separate bucket of time?
And I missed the first part of the question. Colorado has already paid out. What was the first part?
They shared that they've paid out 2 weeks of the Colorado emergency paid sick leave to employees. So their question is, knowing they've paid out 2 weeks already to employees, is the PSST during the public health emergency in addition to that?
Okay, so I have a couple of questions to better answer that, but let me just take it from here. I think what they're referring to is that they've already paid out. So that would be under that first bucket, the COVID-19 relief that we didn't really go over. That was really the federal FFCRA and CARES Act that required 2 weeks of paid leave for a COVID-19 reason that is due to expire at the end of this year. Again, Colorado's Healthy Families Workplace Act really just expanded that so that it applies to all employers in the state, regardless of size. So if what this question is getting at is that this particular employer has already paid out to an employee those 80 hours or 2 weeks of pay that were owed under that, are they now required to pay out an additional 2 weeks under a further public health emergency? So a couple little pointers. Again, if something's already been paid out, that's due to expire at the end of this year. And the accrued PSST time doesn't even begin until 2023. So we really don't anticipate to see that in the future because moving forward in 2021, I think I said 23. So that doesn't kick in until January 1, 2021. So once we move into the 2021 calendar year, we will only be dealing with accrued time available. Now, in a public health emergency, if a public health emergency is declared later in 2021, unrelated to COVID-19, let's say, then an employee is always entitled 8 to 80 hours. So if the question is getting at, is an employee entitled to the 80 hours plus the accrued rate, our understanding at this point in time is no. An employee is only entitled to 80 hours, regardless of what they've already accrued during a public health emergency. Is that clear? So let me try to say it another way. In a public health emergency, an employee is entitled up to 80 hours, not 80 hours plus what they've already accrued. It's just a flat 80 hours. So if they've already maxed out at 48, the employer will have to supplement that 48 so that the employee gets to 80. If the employee has only accrued, let's say, 30, then they're going to have to supplement their bucket with another 50 hours so that they have, again, up to 80 hours of time to take during a public emergency. And whoever asked that question, please feel free to speak up and let me know if I didn't answer that correctly. But
I think that question came from Brian. So Libby, I'm not sure if Brian can have the mic if that answered his question.
All attendees are not able to unmute themselves.
Okay. I'll just leave it. Brian, if you have additional question. Oh, he does have an additional question. Lori, it's clarification. Are we currently in a public health emergency? Meaning on January 1st, do employers need to supplement all buckets of that accrued leave up to 80 hours?
That's a great question, Brian. And unfortunately, I just don't know yet because right now we don't know if it will be extended into 2021. We do not have an end date. So it will be very interesting to see what the state of Colorado does with that. Very, very good question. Unfortunately, I just don't have a definitive answer for you. But that's a great scenario to play around with. Let's pretend that on January 1, 2021, Colorado makes the determination that we are still in a public health emergency, a declared public health emergency as declared by both the federal government as well as Colorado state officials. Does that mean on day one, January 1, 2021, all employees are entitled to 80? I would say probably yes. And we welcome further guidance from the state at this point to clarify that for us. And Tina, you and I talk offline and see if there's anything we can come up with to see if we can get that question answered by the state. But we just really don't know the answer to that. And is that what they were intending by this? We just don't know. It seems to me that the answer would be yes. But let's see if we can get some further clarification from the state.
Absolutely. Thanks, Lori. And we will make a note and do the research and send follow-up to everybody in attendance on today's call. Next question is probably more on clarification on documentation, Lori. Again, when someone returns from leave, is the understanding that the employer is not required or able to ask for any documentation during the current pandemic leave, whether it be at the beginning or at the end?
Oh, that's a great question too, because as you all are aware, the FFCRA does allow for some sort of documentation request. Unfortunately, Colorado's Paid Family and Medical Leave Insurance Act does not permit an employer to request documentation during a declared public health emergency. You can ask for documentation for any of the other 3 reasons to care for yourself, a family member, or in situations involving domestic abuse or sexual violence. You can ask for documentations there, but even then, you're only allowed to ask for documentation when the leave involves 4 or more consecutive days. But in the case of a public health emergency, no documentation can be requested.
Thanks, Lori. Next question, I think we've touched on a little bit because it had to do, again, with the Colorado accrued hours and what's allowed under, or I guess this is under the emergency paid sick leave, which is technically under sunset as of December 31st. But I think the employer's question is, if an employee has already utilized 80 hours and then say at the beginning of 2021, and then later on in the year has another illness, are they required to give an additional 48 hours under paid sick leave, or is that kind of give a framework of the number of hours? Is it over the course of a calendar year, or is it per event?
Yeah. And again, unfortunately, we just don't have a lot of clarity yet. And that's due to a couple of factors. A, we just don't know if the federal government is going to pass a phase 4 relief legislation by the end of this year. It's not looking great right now. So if it doesn't, then the FFCRA, that emergency paid sick leave that we are all referring to, will sunset at the end of this year. So let me repeat that. If a phase 4 legislation is not passed and implemented within the next, I believe we're down to 8 days now in the current legislative session, then employers will no longer be obligated to provide employees with those 80 hours of leave that are offered under the FFCRA. So that sunsets at the end of this year. So now all we're looking at in 2021 is accrued time off. So you are, and then again, that gets back to this earlier question that Brian asked, what happens if, the state considers this COVID-19 pandemic a public health emergency in 2021? Then are employees given 80 hours right off the bat, right, on January 1? If so, then the answer to your question would be yes, an employee has 80 accrued hours that they would be entitled to use at any time. And again, if it's a public health emergency, you can't ask for documentation. They would be entitled to use it as they see fit for any one of those reasons related to a public health emergency. If the answer to Brian's question is no, the state determines we are not in a public health emergency no longer on January 1, then we're just looking at whatever an employee accrues. Again, remember that accrual rate is 1 hour for every 30 hours worked. Unless, of course, you as an employer determine that it's in your best interest to just provide your employees with one lump sum at the beginning of the year, then they would have 48 hours at the beginning of the year to use. Otherwise, they can use it as it is accrued. Again, the accrual rate is 1 hour for every 30 hours worked.
Thanks,
I
Lori.
hope that addresses the question. I know it's not simple. There's a lot of factors in here. And getting back to that question on what's our status as of January 1, 2021, unfortunately, that's going to drive and determine, the proper response to a lot of these questions.
Thanks, Lori. This next question is under the Colorado PSST regulations. And this question says that this employer is already providing salary employees with 120 hours of paid time off annually, and it is payable upon leaving. They said according to Colorado earned wage law. The question they have is, will they be allowed to change the policy and reallocate part of their 120 hours of PTO towards the PSST accrual, or so that it's not required to be paid out. So I think their question is, they're already providing more hours than what the 48-hour accrual amount is. So would they be able to adjust their PTO policy to account for the 48 hours that they're required by law, and then what they as the employer want to give to them outside of that from
and this would, I think the short answer is yes, you will be able to not only adjust, but, continue using your existing policy. I would like to just look at that one-off, though, just to make sure we're crossing all our T's and dotting all our I's to ensure, complete compliance here. But it definitely sounds that your existing policy not only meets, but exceeds the current requirements. So let's just look at that and make sure that we are adjusting it appropriately. So again, without getting too into the details, I would want to actually see it and read it and look at it carefully. But again, I'm sure you can accommodate and use your existing policy to meet the requirements under Healthy Families Workplace.
Okay, thank you. Knowing that we are at the top of the hour, that we're scheduled to go to 11 o'clock, we are going to take one other question, and I know that we have several other questions. What we will do is have Lori provide a response, and we will email that out to everybody in attendance on today's call. So with that, Lori, I think the last question we're going to be able to take this morning is, in your earlier response on the Healthy Families Workplace Act and the definition of temps and how they are independent contractors, when you say temporary, including seasonal, how does that take into account individuals that are working for the employer through a temp agency?
Great question. Great question. And again, that would fall back to the determination on who is actually the employer. And I will need to refresh myself on Colorado law here. As we all know, many other states have adopted other determinations on determining proper work status. I believe Colorado still uses the commonality of interest test, but I'll have to refresh my memory on that one. And it really just comes down to who is the appropriate employer. And many states also use the control test. So if it is ultimately determined that the vendor is the appropriate employer, then they would be the ones obligated to comply and provide the PSST time to that employee, that contractor, or that temporary employee, or even that seasonal employee. If it is ultimately determined that you are the employer of record for the employee, then you are the one that's obligated to provide those accrual rates and time off and benefits. So it really just comes down to who is the employer. That, again, is handled in various different ways. It's either contracted in and with your relationship with the vendor, or the DOL can actually come in and make their own separate independent determination. Again, I believe Colorado uses the commonality of interest and control test. If I'm wrong there, I will clarify that in my follow-up email to all of you.
Great, thanks, Lori. With that, I'm going to turn it back over to Libby for closing of today's webinar session.
Sure. Thank you, Lori and Tina, for sharing your valuable time and expertise with us today. As a reminder, the recording from today's presentation and the slide deck will be shared with you within 24 hours. And the link to the deck has also been posted in the chat. That concludes our webinar for today. So thank you everyone for joining us, and have a great day.